10 to 15 minutes.
Yeah.
Yes.
Your Lordship, with the consent of the other side, my lord, I'd like to mention item number 5. 5, my lord, can it be taken Thursday, my lord? We have some inconvenience, my lord. Regarding 8, they have not given consent, my lord. I have asked for consent.
Uh-huh.
Regarding item number 8 also, I have given a phone, but they
Wait,
have not
wait,
given.
wait.
Item number
And nobody nowadays gives us a request that it will be adjourned. Wastage of 2-3 hours.
from next time, I will do.
No adjournment today. Let us see.
But tomorrow, then tomorrow, my lord.
Wait.
Please, Your Lordship.
Yes.
Well, also with the consent of the other side, I beg to mention item number 9.
Item number?
9. Yes, and this council is out of station, so I pray for adjournment. Kindly 2 weeks time will be granted for the same.
You are for petitioner.
I am for the respondent. Respondent number 6 to 11. We have taken the consent.
21 meter, okay? On the prayer of the learned counsel for the respondent, matter stands, which is responded, which is not opposed by the learned counsel for the petitioner. Matter stands adjourned and be listed after 3 weeks.
Last week.
Any interim order?
There is no interim.
Huh?
No interim order, I think.
Application, my lord. Lordship order dated 26/7/2024, my lord.
My lord, we are filing today, my lord. Just we have handed over the copy. So some other day, my lord, take up something.
The Learned State Council submits that pursuant to this court's order dated 26/7/2024, an affidavit is being filed during the course of the day. In view of the above, matter stands adjourned and be listed when?
After 1 week, man.
My lord, fix a date within 10 days, my lord. In that
Oh,
case,
you
I
were
file
not
reply.
present on last occasion.
We file reply, and my lord,
After
matter will
10.
taken up at admission.
After 10 days.
As admission.
Why?
But already, my lord, so all are appeared and
Where is the problem taking admission or orders? Orders is advantage for you. It will take in the
my
after 10 days.
absolutely.
Yeah, please, Your Lordship. Lordship, the matter may be taken after some time, my lord.
Item number?
1, my lord. After some time, the brief is, my lord, due to the rain, my lord. Obliged.
Ready? Whatever.
Yes, madam. In this case, Your Lordship, I have prepared a short note for Your Lordship.
And you have marked up flex this.
Yes, madam.
Huh?
Along with the case there.
Okay, case there.
Yes,
Have you marked the important things?
Yes, madam. My lord, regarding some of the photographs were also earlier there, but those photographs are right now not.
Not necessary.
Yes.
Photograph will be good.
Yes, well, earlier, my lord.
And you have dealt with that issue of this in your note, na, that regarding.
I prepared a short for Your Lordship assistance,
Uh-huh.
madam, otherwise that along with the inquiry report, everything.
Okay, we will not pass the order right now. We may fix it, either make it CAV or fix it on Thursday to deliver the order.
Yes, madam.
We'll pass the order later. After going through your things, we'll decide accordingly.
Yes.
We'll pass this order. Next.
This is on the last occasion, Lord Sir passed the order on 23/7/2004.
Excuse me, to CAV हो गया something. What are this? 12.
23/7/2004, Lord Sir passed an order
Uh.
to file an affidavit by Deotha, but they have.
Lordship, yesterday evening, Lordship, I have received the instruction, Lordship, short instruction, Lordship.
What is the issue? Tell us.
But see, kindly before that come to the order dated 14/11/2022.
14/11,
And elaborately discussed and just for the payment 14/11/2022.
14/11,
14/11 also. Where is the
23.
22? 14/11/2022, Lordship. Honorable Justice Devashish Baru has passed an order where both the cases were elaborately and alleged cases were
14/11.
taken up.
22.
22, Lordship. Lordship, permits me to read to judgment and I will read it.
Huh? Yes, tell us which are the.
There are 4, 5, and 6, my lord, very relevant. Page 4.
Page 4.
Yes, my lord. In LA case 32, 2009.
That relatable to LA case. Now this is WPC 7220.
Page number 6, Lordship. My
Okay.
part is page number 6. Lordship. Now coming to the fact that the WPC number 7720/2015, which relates to LA case number 47/2009, it appears from the said additional affidavit filed by the respondent number 3 on 1/8/2022 that notification under section 4 of the Act 1894 was published on 19/10/2013 in the official gazette, and said notification was under section 4 of the Act was published in local daily newspaper on 19/1/2004. As in the case of section 6 of the Act 1894, the notification of the official gazette was issued on 23/12/2013 and the same was published in the local daily newspaper on 31/1/2014. Further, it appears that although the award was forwarded by the government on 27/12/2013, but it was approved by the government on 29/1/2014. And the said amount was sanctioned by the respondent number 3 only on 15/2/2014. Therefore, it would also appear that the taking into note that section 12(2) of the Act of 1894, the award was filed only after coming into effect the Act of 2013, and therefore the compensation has to be determined in terms of section 2013 for the reason. So initially some part payment has been made. That was also when the new Act was. That was a part in my case. In their case is separate. That is what because they have nothing paid. No amount was paid. So in my case, I challenge it, Lordship, come to the writ petition part also. So that was decided. Then, Lordship, as per the direction of the Honorable Court on 19/7/2013, an additional affidavit in opposition was also filed.
By whom?
That is NHS Judicial,
Hmm?
National Highway.
What is just 10?
That in that
185, my lord.
Page
185.
Page 185.
WBC 1586, lordship. And another 7220, it will start from page 74, my lord.
70.
4. There are 3, lordship. One starts, lordship.
74.
Yes, 75.
File by the respondent number 3.
Respondent number
That
3,
is,
lordship.
you.
Subsequently, respondent number 5, my lord.
This is by one nursing power. Page 74. Nursing power IAS.
No, no,
So
Lordship.
Vivekanand Jha,
Vivekanand Jhala, my lord.
Vivekanand
WBC
Jha, Lordship, that is
Lordship taking the file of 7220, Lordship.
7220.
7220.
It will start from page
Vivek,
74.
Vivekananda Jha.
Yes, my lord.
It's
Vivekananda Jha.
95.
Yes.
He submitted,
Just a minute, just.
yes.
Hmm. What is his then?
May I read, Lordship?
Yes,
For
paragraph,
Paragraph from 3 starts, it will, Lordship.
paragraph.
Only 4 paragraphs, my lord. That the land of the petitioner was acquired by the additional deputy commissioner Tinsukia for construction of greenfield pass of existing Digboy Margarita Lido Town section so and so on behalf of the acquiring agency, that is PWD NH division, Lordship. Government of Assam under the Land Acquisition Act 1894. Upon perusal of Honorable High Court's order dated 14/11/2022, just now my friend has Lordship. It is noted that under section 4(1) of the Act of 1894 published on 9/10/2013 in official gazette, and the said notification under section 4 of the Act of 1894 published in the local daily newspaper on 19/1/14. Further notification under section 6 of the Act of 1894 was notified in official gazette on 23/12/2013, and same was published in the local daily newspaper on 31/1/2014. After declaration of the award, possession of acquired land was handed over to the Executive Director PWD NH Dibrugarh by the ADC Tinsukia. As such, office of the deponent, that is NHIDCL, was nowhere involved in the said land acquisition proceeding. Next paragraph, Lordship. That on 26/6/15, the existing tracts of NH 38 was entrusted to the NHIDCL by the Ministry of Road Transport and Highways, New Delhi, by notification dated 26/6/2015 for development of maintenance of kilometer 20 so and so so and so. Next page, next para. The later on, it was decided that
Okay,
development.
so according to you, initially it
Yes,
was
sir.
NH division, they
PWD.
maybe PWD NH
PWD.
division.
PWD.
Subsequently, it was handed
Handed
over
over,
to
Lordship.
E.
Yes. Para
So
5, my lord.
other dispute is not there, that award was passed subsequent to that, there is no dispute to that effect. Only dispute is that whether, yes, para
Para
practice.
5, Lordship. It is relevant, Lordship. That later on, it was decided that development of bypass will be taken up by the NHIDCL. Therefore, the land acquisition acquired by the state government and possessed over by the executive engineer PWD NH Dibrugarh has been handed over to the NHIDCL by the Kala Tinsukia by letter dated 9/9/2022. It was handed over in the year 9/9/2022, Lordship. The total land handed over to NHIDCL by the Kala comprises of total 70.260 hectare for the 13 number of villages, namely so and so, so and so. Next, Lordship.
Hmm.
It is to be stated herein that at the time of transfer of the said acquired land, no condition for payment of land acquisition was intimated. And also no information about any application or anything pertaining to compensation of the transferred land was brought to the notice of the NHIDCL by the Kala Tinsukia. It is further to be mentioned herein that as per extant guideline of the Ministry of Road Transport and Highways, New Delhi, the land vesting in the central/state government is transferred to the central government more free of cost, Lordship. If the land was earlier of the state government, then it was handed over to the central government, that will be free of cost, Lordship.
But who, land will belong, the road will belong to whom?
Now,
Now,
Lordship, initially it was taken by the PWD department.
no, so therefore it was, land will now vest in the central
Central
government.
government, Lordship.
So
It was
if
transferred
road,
from the
if
state government to central
state
government.
government, so now road is vest with the central
Central
government.
government.
So therefore, subject to whatever you say, they, if they acquire a property, their benefits and liability, both will to be taken by them. Isn't it?
Lordship, but initial.
No, we understand. Initially it was state,
State government, Lordship.
but suppose in such a situation, who will pay then?
State government, Lordship, because they were the earlier acquiring agency, Lordship. Because
But
it was
ultimately,
later on handed over
ultimately,
to the
suppose you put a toll gate on that road, who will have the income? You will maintain the road. Cost is yours. Whatever income comes, it will be yours. So when a property is given, it is given with both assets and liabilities. Debts and liabilities both will be with, subject to what you argue. So some authority that no, you are not
And
entitled.
in this case, Lordship, acquiring agency earlier was PWD department.
No, that we understand, but
And the
ultimately,
writ petition also, they have not included the PWD department. That is also one point, Lordship.
Required actually.
state is a party.
State is the party.
What is the stand of the state?
That is exactly.
The-
Last affidavit of the file, in my case, that is on.
So tell us, what is the
And
stand of the
Lordship,
state?
And one more standard, Lordship, one more stand.
Has to be
In
paid.
WPC, Lordship,
National Highway, they have shifted.
Lordship, in
National Highway.
WPC 7220, Lordship 2015,
Hmm.
they have already received an amount of rupees 1 crore 92,000 something, Lordship.
That
And
is in
it
the-
was
yes.
compensated as per Lordship old act, Lordship.
That's
I
why.
understand. So we are not going
enhance
to, we are not
exactly.
going who will get how much. We cannot. This is not our job. What we can determine is that which is the law applicable, shall be applicable to the land acquisition process, number one. Number two is who will have to pay. That's all. What will be the amount? That will be the determination of by the authority, Kala.
That is to be.
That
decided,
is to be
Lordship.
determined. Now, what the law says. As on date, the law, because there are some diverse views, then it was referred to a larger bench. What was the decision of
Lordship,
the
indoor development. Lordship.
indoor development? Now, whether this indoor development, as per indoor development authority, that view taken by the coordinate bench recorded, this was after indoor development authority. What is the date of indoor development authority? Pronouncement of indoor.
That's comes up, Lordship. That is-
Second of January 2023.
Lordship, it is reported in 2022.
No, no, see,
just
date is important.
Lordship.
2nd of
No,
January
no, that is
2023.
different on the basis
Second
that-
of January 2023.
একটু নহয়, on the basis of-
Now, what is the ratio in indoor development? That is the vital issue. What in the, because this order was passed on 26 in the year 2022. Now let us see indoor development authority. Citation,
Lordship, I have the copy, Lordship. Citation, Lordship, 2028 SCC 129.
2000,
20,
no, subsequent larger bench decision.
Lordship, 2020, Lordship,
It was delivered on which date?
it was delivered, Lordship.
Not 20. Indoor development authority was referred to a larger bench, is not it?
Yes.
Huh? No, sir. Hmm.
Yes, sir. Yes, Lordship, that was the Lordship, Constitution Bench, Lordship,
Uh-huh.
2028 SCC 129. Para, my lord, 366,
Para,
366, Lordship.
where is the judgment? Do you have a copy?
Yes, Lordship. On the basis of that judgment, this was Lordship, para is quoted, Lordship.
When it was made, award was made on which date?
Lordship, award was made, Lordship. Six one 2014 Lordship.
Huh?
6/1/2014 Lordship. In the order, Lordship, of this Honorable Court 14/11/2020 it is reflected, Lordship.
So there is no question of lapse in this case. So it will continue and compensation is to be paid under 13. In terms of 366.1, it says under the provision of section 24(1)(a), in case of award is not made as on 1/1/2014, the date of commencement of the act, there is no lapse of proceeding. Compensation has to be determined under the new act. Proceeding will not lapse, but compensation under 2013 act.
But in this case, in Honorable one, Court of Award.
And next para, Lordship, 3663, my lord. Next
Yes.
para.
In case of award has been passed within window period of 5 years, excluding the period covered by an interim order, then the proceeding shall continue as provided under section 2 act under that, and if it is not been repealed.
Next para.
So,
Next para, my lord. The word
give the book.
land acquisition. Oh, yes.
2013.
Right to
39. Give us our book that is there.
24.
Okay, then you argue on the merit of this case. That we Adaraji understand. You say that this act will be applicable on and why. That's all.
See, that's why I have submitted my part, that 14/11/2000, that was.
Let us see, let us
Yes.
let us
Yeah,
record
yeah,
the date on the
yes,
basis
Yes,
of
yes, yes.
And who are these other petition? Who are they?
Lordship, background of the case is that we are not, we are ready that, and our only prayer was that compensation has to be made as per the new act. Accordingly.
Did you get anything prior to?
No, no.
Any land has been acquired, your land acquired?
Yes, yes. That is the position.
Now, do they dispute that your land is acquired or not acquired?
No, there is no dispute regarding that. But one thing is certain, that who will make the payment?
No, no, sir, we'll come to that. In his case, notices were there, he was, notices were issued to be, treating it to be an interested party. Accordingly, compensation was paid. His case is that compensation is wrongly determined. In view of this provision, we are entitled for enhanced compensation. This is one aspect. In your case, there is no compensation paid. Why?
No, because we moved the High Court, Honorable Court.
No, was there any notice?
No, that was haphazard manner in a very, just on the verge of.
No.
So
Were
we-
you notified to be under, treated to be an interested persons, your land?
Yes, yes, yes,
Your names were given, you were,
Yes, yes.
you were given notice.
yes.
So after notice, you said that we are not acceptable to this compensation.
Yes, we moved the authority, then finally we came before your lordships in 7 writ petitions containing some villages of around 40 petitioners.
Now, how can association and committee can maintain a
So
writ petition?
actually, your lordship may turn to an order because 70
17 of what?
of the.
Mr. Talukdar,
Lordship,
we'll come to this principle of
Lordship.
law to let us understand his fact,
Lordship.
how he is affected, because what state says about him? This person, what is the stand of the state?
State, Lordship initially paid the first part payment that has been made.
To you, not to them.
To them, them.
Them.
Our
We
part is-
understand your case.
Oh, yes, yes.
Your thing is that whether
That's
we
what-
agree or not, your case is that, see, this was my land. The notice was given, everything was done.
Everything was.
Everything was done. You have paid some compensation,
Exactly.
but in the change of the legislation
Yes.
and non-passing of award, we are entitled for compensation under 13 Act.
New Act.
Okay?
Yes. yes,
This is
yes.
your case.
This is my case.
Their case is, NSIDCL's case is that we are nobody in this proceeding. Because it was at that time of acquisition of land, we were not in the scene.
Yes.
Subsequently, it was to be, the land was to be constructed by the NHPWD NH. And therefore we are not. Subsequently, we have given the land to be a government land,
Yes.
free of cost.
Yes, Lord.
Yes.
Therefore, in that perception we have constructed, how can you fasten the liability?
Yes.
This is,
That
this is their
that is
case.
only their stand, yes.
State
That is-
case is that
Yeah.
that property belongs to you, whether we hand it over or we have handed it over.
Yes.
So moment we hand it over with assets and liabilities, it is you.
It
We
is-
don't have. Even if you put a toll gate there, earn income, you will not share money with us.
Exactly.
Isn't it? This
Yes.
is the state's case.
This is the
That is
stand.
fine. We'll come, we'll have to make a determination.
Yes.
Then when, depending upon the dates, which act will be applicable?
Yes.
If we hold that it is rightly be given, we dismiss your writ petition.
Yes.
And if we hold that no, entitled under this, we'll just
Yes.
simply relegate to the kala and to determine. That's
Yes,
all, with
yes,
nothing
yes,
more.
Yes.
Now we want to know the land affected person. Who are they? And what is your stand?
Specifically, my lord, we have not taken any defense on the locus, my lord. We have filed.
No, we are not on locus. See, forget about, okay, some people join together, they have a common cause of action.
Yes,
We'll also not go to that technicality.
my lord.
But the question is whether while issuing notice under section 4 or 6, their lands were included. Their lands are part of the notice.
My lord, to that extent, our affidavit says, my lord, that some part and parcels of their land, my lord.
So how can we decide anything here?
Yes.
Even it is not sure who are the affected parties.
Yes. Yes.
That's why I'm asking association.
Absolutely.
Mr. Sharma's land might have gone. His neighbor may not be.
Yes.
So
Absolutely.
ultimately, in
Yes,
his
yes,
case, we'll have to
absolutely correct.
relegate it to the deputy commissioner to decide whether actually their land has been taken, if
My lord,
taken to
that-
proceed
that would
accordingly.
be, my lord, the best course of
No, no, we cannot decide.
We-
Yes,
yes.
what do you say?
At this stage, his admitted position that our lands were taken.
Ours means whose?
The
All
parcel-
petitioners and names are there.
Yes.
Have you given a list that this land, this amount, this much?
No, no, to that extent.
Then
the
how
petition is
can
silent.
we decide that?
First of all, my lord, actually, lordship, I may say that we filed separate writ petitions, lordships, on the first occasion.
Hmm.
And there, we have also submitted, and accordingly,
Hmm.
this honorable court directed the government to dispose of the petition, because
Hmm.
that point was arose whether the act will cover national highway or national.
That will decide in the other case.
Ah.
That will decide.
Then-
That means it will depend upon the award was, when award was passed and when act into came. That principle will lay down. But thereafter, what next in your case?
Then they passed an order
Hmm.
rejecting our application. Then.
What
we-
was the ground of rejection?
The action was different, that they said that it is not national highway applicable, act is not applicable.
No, that is fine. That is a question of law.
Then
will
we
decide.
came before your lordship. Then finally these two cases were tagged. And hearing this court has also.
What is the challenge in your writ petition?
Now we have challenged that we are to, since.
Let us see your prayer.
So in that.
We are not
lordship,
here to determine who will get
Lordship.
how much compensation.
I
You
humbly
should be
submit
clear.
that my matter in that case may kindly be taken up on 27th. 27th of this month,
Your is 1586.
1586. Because senior counsel is also very much involved, BC.
Who is senior? Who's senior?
BC does. So my matter may be segregated and this may kindly be taken up on 27th.
They have basically.
That we understand. We will adjourn it, no problem on this. People's rights are surrendered.
Yeah.
So many days is pending. But you brief your senior that what can we determine in this writ petition, except laying down the principle of land, law, what act will be applicable? That's all. Can we say, no, these members of these societies are entitled for land acquisition compensation? There may be many claims. There may be dispute regarding apportionment. There may be dispute regarding entitlement. Can we decide all this in a writ proceeding? What we can say is that land acquisition pursuant to notice dated so and so, section 4, section 6 did not lapse, and it is to be, however, the compensation is to be paid in terms of section 13. This is one way. And other way is that no, since in view of the Indore development judgment, the compensation they are also entitled on the basis of the earlier act. Either of the way, these two will decide, and thereafter we relegate the matter to the deputy commissioner or Kala authority, Kala, and we'll say that you determine what should be the compensation in terms of the laid down principle laid down.
So if it is to be relegated to the Kala, my lord, then my lord, the 1956 Act will come
No,
into
no,
play.
no.
No, since my lordship has posed a pointed query, my lord, in their writ petition, if we come to the prayer person, they are claiming, my lord, that directing the respondent number 7, that is the Union of India, to draw up appropriate proceedings under the 1956 Highways Act. So they have acknowledged the fact that the part and parcels of land in question are being used by the highway authority. So therefore, they say, my lord, that whatever is gone, everything has left, everything has become infructuous. Now, let
Yes.
us command, my lord, the Union of India. This is their prayer.
So 2030, according to them, everything is to be initiated afresh under, so everything is lapsed, so new act. This is your case.
Not even 2013. That is the interesting part. They are seeking a remedy under the 1956 Act.
National
1956
Highways Act.
National
But
Highway
Highways Act also 13 will come.
Yes.
2015, that is different.
1956 is a different act. There, my lord, the authority will be Kala, as has been rightly pointed by my lord.
Okay, let us first decide the issue, the land. Okay.
Ultimately, at the end of the day, what has fallen from my lord is that is to be
That's
determined.
why
Yes,
so
yes.
many years these matters are pending, we do not know.
Yes.
Yes, tell us.
My case,
We'll finish it today.
my case may be on 27th.
Wait
It will
for
be-
some time. Let us understand.
Because in this case, we have to argue in that line. Because till now, only that was.
Nowadays, arguments are pointed out that this is your case, you argue it. Isn't it? Those days are gone,
Those things
days
are
and nights.
submitted.
Yes.
Lordship earlier.
Yes, we'll give you time. Yes.
Lordship,
Tell us.
Lordship, come to the order
Refer
date
to,
first.
no,
Lordship.
forget about earlier orders.
No, Lordship, because that the 4 issues which are involved has been framed on 28.
Oh, we understand. We want to know the facts on our own.
Yes.
Let us record. We'll see.
Yes.
We'll refer to that order.
No, the
We want to see,
affidavit.
we want to see the documents.
Yes,
First, see the notice, section 4.
yes, Lord.
I can ask him to go.
Yes, Lord.
Yeah, Materi. Just a
In
minute.
that,
Just give me a minute.
yes, Lordship. Lordship,
Yes.
the section 4 and section 6 notice,
Hmm.
Lordship, they have, government have enclosed on 1/8/2022 in their additional affidavit.
No, no, don't say all this. These are
No,
not
no,
relevant.
because
I am
my-
asking you, give the date.
Yes, sir.
When
Date.
section 4 notice was issued?
Yes,
19/10/2013.
yes, Lordship.
Is that it?
Yes, Lordship.
Which page?
Yes, Lordship.
Page.
Yes, Lordship, because that affidavit, that section 4 and section 6, I have not enclosed in my petition. That
Oh,
was,
you have not
their
enclosed,
affidavit.
no difficulty.
oh, yes, that's in page
No
number.
difficulty. We are
Yes.
asking you what is the date and which page of this paper book.
Yes,
That's all.
section 4
Ah,
in 19/10/2013,
hmm,
that was in published in 19/1/2013. This is in page number, Lordship,
hmm.
6 of the additional
No,
affidavit.
no, there is no continuous page.
Petition page 30, Lordship,
Huh?
7220, no?
Yes, 7
Ah,
to
7 to
30,
2,
page 30.
page 30. Dated 13/1/2000.
13/1/2000. Thanks. Just my. Yes, Lordship. I've got it.
It will be 19/10/2013.
Page
Page my lord 30,
30.
page 30.
Yes.
Okay.
Prior to that also lordship will find, because there are two land LHSs. Prior to that, lordship may kindly see my lord,
1910. Page
uh,
28.
page 28, yes.
Yes.
I'm so obliged, my lord.
Page 28 and 30.
Page 28 and 30.
Now,
Page 28 was published in Dainik Janambhumi and page 30 was published in Assam Tribune, my
Assam,
lord.
okay, which are your lands? Whole land belongs to you.
The whole land.
There is no dispute to
No
that.
dispute. Yes,
So the land enumerated under this notice dated 19/10/2023 belongs to you.
yes, Lordship.
That is NLR Lido Tea Estate.
Yes.
Okay?
Yes.
Okay, then when was the Gazette notification?
That Gazette notification dated the notification 9, that is 19/1/2014,
Mm-hmm.
19/1.
No.
19.
That lordship will find that page 35A.
512.
Yes. 20,
Mr.
23,
Sharma is not ready.
20,
No,
page
Lordship,
12,
the
2013.
2312. Page 35A of the.
2312, say that is section 6.
Section 6.
Section
this is-
6.
That is section
No,
6.
section 4.
Gazette notification on 5/12/2013.
Gazette notification of 5/12/2013, that lordship will find, my lord, this is 19. That is not there, but
That is-
this appears, my lord, this is otherwise, my lord, the notification.
What is page 36 then?
Page 36, my lord, is the original, and
New-
page 34, 35 are, my lord, the type copies.
No.
36 is Lordship, RFPPL Act come into force.
The new act will come up.
36 is defined,
That is-
36 is defined, 36 is with regard to, my lord, coming into effect of the new act.
New act, yes.
Okay, now
Because-
when 16 notice was issued on 23/12.
Yes.
23/12, yes.
Therefore, lordship, if lordship is perusing page 35, page 35 down below, my lord, last but one paragraph,
Mm.
lordship will see, my lord, I am reading it, my lord, that the
Declaration is made under provision of section 6 of
section
the act.
6.
Is not it?
So this is the final notification. Now, the matter is to be seen whether, my lord, the award is passed.
Now section 6 is at page
Page, my lord,
35A.
35.
Huh?
35A, yes, precisely 35A.
Now come to award.
Yes, that lordship will see, find at page 37,
7,
Page
page 37.
37.
29th of January 2014.
Absolutely, my lord,
Is that it?
Yes.
absolutely. So that.
29th of January 2014. Just a minute. Just a minute. Page is 37.
Yes, Lordship.
Okay.
Then Lordship, page number 40, Lordship, kindly.
12-2 notice was on page 38.
Yes, Lordship.
Is that it?
7, yes, Lordship. 7/3/2024, 2014, Lordship.
Now here, my lord, at page 37, lordship may kindly take note of the date, my lord, with all
Page
respect.
37.
Page 37, this is the award.
Hmm.
Kindly see, my lord. The date is, my lord, 29th of January. So that means 29/1/2014. Now, the new act has been made applicable from 1/1/2014.
Yes.
Now, section 24 of the new act, my lord, gives the saving powers. Now, under section 24, my lord, where an award has been made, my lord, then proceedings shall continue under the provisions of so and so, as if the act has not been repealed. Where no award has been made, all proceedings per so and so determination compensation shall apply. Section 24A,
Huh.
24(1)A,
So
24.
according to you, if we treat this 29th of January to be award, what is the effect?
It will be, effect will be, my lord, that where no award under section 11 of the
So
earlier
act comes into force on 1/1/2014.
1/1/2014.
14.
And-
And on 1/1/14, there was no award.
1/1/14, there was no
No
award.
award.
No award.
So award was passed on 29th of January 2014.
29.
Now what is the implication under section 24?
Implication, my lord, plain reading will say, my lord, this will lapse, but 2013 Act will apply. But Indoor Development Authority has clarified that if for one reason or other, my lord, within a span of 1 year break, my lord, that the proceedings has not culminated into an award, then it is saved. It is saved.
That is why I'm insisting on Indoor Development
Yes,
Authority.
so therefore, my lord, according to this quantum of money, my lord, that has been determined, they have been paid a part of the money. It is not their case that they have not been paid with anything.
So you have determined under the earlier act,
Yes,
and your case is that earlier act will be
earlier act will be
here.
Act will be applicable.
And your case will be that in Indoor Development Authority, in terms of Indoor Development Authority, this proceeding will not lapse, including so far relating to the compensation.
Compensation. But now, my lord, since the time has elapsed, my lord, sufficient time has elapsed. Now, an amount has been determined at an earlier point of time. Now, if they have not been given granted with the total quantum of, my lord, the awarded sum, then they will be, my lord, entitled to additional interest. So those matters will be there. Those things will be calculated in terms of, my lord,
New Act.
2013 Act. Because now 1894 Act, with all respect, my lord, it is.
Now let us see the act first.
Yes.
This will be case of Mr. Talukdar also. According to you, even if we are to pay, this is to be paid under the earlier act.
And in our affidavit, my lord, we have taken a specific place that this notification, my lord, on 27/12/2013, which lordship has posed the query, my lord, we have taken this notification to be an award. Because that page 37, which I have drawn my lord's attention, this is a communication of that award. But the award by itself was passed on 27/12/2013. So if it is 27/12/2013, we are saved, my lord. This is.
Already there was an award,
There was an award and
but money was not paid.
money was not paid.
What will be the effect of non-payment of money?
Non-payment of money, my lord, they will be entitled to, my lord, interest.
No, Lordship. The thing, Lordship, kindly, page number 37, from the thing is calculated from the approved of the award. When the award was approved, the award was approved on 29/1/2024. So when
So
the, yes,
according to you,
No.
award came to have seen the light of the day on 29th of
January two
January
thousand twenty-four.
2040. By that time already act was there.
Yes. Secondly, that whatever the old amount that was paid, second, two things is important, Lordship. That amount was received under protest and handing over, taking over, that is also come into the new act.
Mm.
So all these issues were decided, and that's why I come to the.
I'll come to see.
Yes, yes, yes.
We
Yes.
want to, since this court is
Yes,
hearing, we want to
yes.
understand the facts.
Exactly.
Or otherwise,
Yes,
what I
yes.
can do is forget or will not hear, will copy and paste that order
No,
and say
no,
this
no,
is
Lordship.
correct. This
No,
is not the order.
No, no, Lordship, because in this case, the records were also called for. That I could come to.
No, that
present
will come. It's not that
Yes.
we have finished this
no,
argument.
no.
We want to understand ourselves,
Yes,
then
yes,
we'll go
yes.
to the order.
Yes, yes, yes. No. that's
Or
what
if
I-
you say that, no, that copy that order and paste it and
No,
pass the
no,
final
Not that, Lordship. So, so
communication.
with the approved copy of the award.
Because under the law, my lord, as far as I understand, treatment.
Now,
with-
what was the, something is recorded in the earlier order.
Yes,
So that was on the basis of record.
record.
So that is his, why I'm asking you this question, let us first understand. Now we'll go to that order. You want to go to the order straight away? Because it will shorten his
Yes,
things.
because on that order basis, Lordship, affidavit was filed by the government.
And in the
That is-
affidavit, we have taken a clear stand.
Clear
My
stand.
lord, my learned colleague has not bothered to make any response. to my
On that
affidavit.
basis, that order 1411 award
So
was,
my
that
affidavit will
order was
stand.
passed.
My affidavit will stand. No, open pass order,
Yes, good.
but my affidavit will stand on record.
28/6/2020.
ইয়াতে Go back on it, 11, 26. Sorry.
Okay. Yes.
28/6/2020. Order 28/6/2020 states that. So and so
Order dated
28/6/2022, Lordship.
20,
Yes. Honorable Justice Manish Chaudhary, Lordship. 28/6/2022.
23.
22, Lordship. 28/6/2022, Lordship.
6. Yes.
are Mr. So-and-so, so-and-so, WPC number 720, the BC Das Landon so-and-so, Arun so-and-so, and WPC so-and-so, so-and-so. The state responded in both the writ petition are to clarify on the following aspects. First, publication of the notification under section 4 of the Land Acquisition Act 1894 in the Gazette through the newspaper. Publication should
Now,
to
that we have understood. Now, what was the date of approval? In the
29.
affidavit,
Yes, in the affidavit, Lordship,
Hmm.
that is 1/8/2022. This is Narasimha Pawar, IS officer, he has filed that affidavit, Lordship.
Uh-huh.
1/8/2022,
No, according to him,
yes,
what is the date of approval by the government of the award? Because this
Award-
approval having a relevance.
by the good, that paragraph.
That
two-
will, under section 11
Yes.
of the earlier act,
Yes.
section 11(1) or something like that.
Yes.
What was the date of approval?
29/1/2014, in paragraph number 8 of their affidavit. The deponent begs to state that award in respect of paragraph 8,
Paragraph 8 of
8 of the affidavit, Lordship,
filed by
filed by the
Deputy
government,
Commissioner.
respondent number 3, additional
R3.
affidavit.
R3.
Yes, Lordship. On 1/8/2022.
Additional affidavit pursuant to discourse.
Yes, Lordship.
Okay.
Pursuant to this order of this court. So where they have said that deponents finalized award and forwarded the same to the government by letter dated 27/12/2013, which was approved by the government on 29/1/2014.
Okay. Just listen to
Yes, sir.
this quote, okay? We are just starting the dictation. You facts, we are not dictating on the judgment. The facts, then we'll record your argument, their argument, everybody's argument. Let us not waste time.
Yes, sir.
This is the prayer page. Below WPC 7220,
Yes, my
2015. No, not necessary to write anybody's name, just whatever they are. The petitioner tea growing land under Lido Tea Estate in Makum Moja of Tinsukia district were acquired under the Assam Land Acquisition Act 1894, hereinafter referred to as Old Act, for construction of the bypass on National Highway 38. Land acquisition proceeding being LA case number 47.
Yes.
47 of 2019, 2009 was issued.
2009 lots.
2009 was issued. Full stop. Certain compensations were also paid, which was accepted by the petitioner under protest, as well as possession was also handed over under protest, which shall be dealt in details in the later part of this judgment. Full stop. It is the case of the petitioner that in view of enactment of right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013, hereinafter referred to as New LA Act, which became operational on 1/1/2014. The petitioners are entitled for land acquisition compensation in terms of the new act, New LA Act. In terms of the new act, However, as their prayers are rejected, the present writ petition is filed. On the full stop. For the proper appreciation, let this court first record. Full stop. During the course of hearing, a coordinate bench under its order dated 28/6/2022 directed the state respondents to file an affidavit and to clarify the following aspects. Okay, Roman 1, 2, 3. 1. Date of publication of notification under section 4 within bracket 1 of the old act in the Gazette and through newspapers. Next, 2, Roman 2. Publication and declaration made under section 6 within bracket 1 of the old act in Gazette and through newspapers. Next, 3. Finalization of the award by the collector. 4. Approval by the government to the award. 5th, disbursal of the compensation amounts, if any. Full stop. Accordingly, an additional affidavit was filed clarifying the aforesaid point by the respondent number 3 on okay, just give find out
1/8. You received the copy on 1/8/2020.
on
Yes.
this.
1/8/2022.
1/8.
1/8/2022.
From the aforesaid, just give make correct us, huh?
My lord.
The following facts are from the aforesaid additional affidavit. Following facts are discernible. Notification under section 4 of the old act was published on 19/10/2013.
19/1.
19/1.
19, they have corrected it.
Yes, my lord.
19/1/2013.
Notification was published in local daily on 19/1/2014.
14.
19/1/2014
2014. actually.
2014.
Yes, sir.
Correction, please.
in the official gazette.
Yes,
No, the 19 was published on 19/1/2014
19/1, 2014.
that, lord,
in official gazette.
my lord, I am coming, my lord. My lord,
And
that,
daily news, give us the 2 dates. One is official gazette, one is daily newspaper.
yes, my lord,
Yes.
on, in the official, in the official gazette, it was published, my lord, on 23rd of December 2013.
No, that was 6.
6.
I am
that is-
asking about 4. That's why I from
No,
from the first part.
1910.
My lord, I am coming. my lord.
19/10/2023.
My lord, that gazette notification is, my lord, 19/10/2013. Four.
That is what I have said.
My lord, I'm sorry, my
1910,
lord.
yes.
I'm
That
sorry.
is what I have
Yes,
dictated.
yes,
Yes.
19.
But you,
It is
oh, okay.
1910.
Just repeat it, huh? From the aforesaid affidavit, additional affidavit following undisputed facts are discernible.
My lord,
1. Notification under section 4 of the old act was published
in the gazette, my lord,
in official gazette
My
on
lord.
19/10/2013.
my lord,
Full stop.
obliged, my lord.
The said notification was published in local daily newspaper on 19/1/2014.
14.
14.
One is 13, one
Yes.
is 14,
One is
isn't
14.
it?
Yes.
2014.
Yes, my lord,
Full stop.
yes,
Notification under section 6 of the old act was published in official gazette on 23/12/2013
14.
my lord,
and The same was published in local daily newspaper on 31/1/2014.
Absolutely. Yes.
Okay. Now come to the award.
Award.
The award was forwarded by the deputy commissioner, the collector
Collector. On 27/12/2013.
on 27/2012. Full stop.
2013.
13, sorry,
Madam,
sorry,
madam.
2013.
My lord, my lord.
The said award
Ma-
of the deputy commissioner was approved by the government on 29/1/2014.
Yes.
14.
Okay, full
Yes.
stop.
Yes, yes, my lord.
14.
Yes.
The amount so awarded was sanctioned by the respondent number 3 on 15/2/2014.
Yes.
My lord, my lord.
15/2/2014.
Absolutely, my lord.
Full stop.
Notification 4.
Hmm.
In newspaper.
31/1.
Mentioned it as 19/10/2013.
Ah,
19/10 this has a official gazette.
Paper publication is another date,
Publication
31.
date is Dainik Janabanghi 31/1. Lordship should get it 28.
just tell us, I'm just repeating.
Original पे আছে?
Original to the tomorrow.
Yes, section
It-
4,
it-
paper
it-
publication
it-
was on
it was-
31/1.
It was there by March.
See,
it-
just I'm
2014.
telling you. That's why we are saying.
Wait a minute.
Yes,
19 হৈছে। এইটো record কৰিলে? সেইটো
the paper publication,
এইটো memory type কৰি দিয়া বস্তু।
no, no.
So I'm going from the original,
Yes, yes,
that
definitely.
not type copy.
Yes, yes, yes.
Yes, yes.
But section 4, the publication, newspaper publication, that is date, if let's say 2 newspaper is required.
No, we are giving one. They're not necessary. Let us not.
Lordship is
Oh,
going by
yes.
the hard annexures, my lord.
That's why I'm saying.
Let us not go to
So
the.
therefore,
critics.
correct me.
The
Why I have
critics
started?
are all, my lord, inconsistent.
No, the
Even I will admit, my lord.
No, no.
Everybody is pleading.
So
this
why I have started dictating
Yes.
that there is no dispute as regards this.
Absolutely.
But the regarding section 4,
Hmm.
the date is correctly noted that 19/1, but the 19/10/2023, but paper publication in both the newspaper,
Hmm.
that has to be reflected in the order because page number 20 and 30. I have
Section
included.
4.
Section 4. Publication of the both the section 4 notice gazette is 1910 is 2013 is correct. And local daily newspaper,
Was 19/1/2014.
yes.
That I have already dictated.
Yes.
I have already dictated. that.
Yes.
What is it?
Pleading কৰিলে মাথা গৰম হৈ যাব এইটো ক্ষেত্ৰত।
See, this is not a judgment. This is, we are recording, just recording. Clarify the facts. Later on we'll.
I must fairly admit, my lord, all the pleadings are, my lord, inconsistent.
Therefore, that's why,
Nobody is knowing what case they are projecting, my lord.
okay. Now.
Lordship is going by the affidavit, my lord, I am obliged.
No, that facts are almost clear.
Absolutely.
These are clear.
These are the most vital facts.
No other facts are required.
Yes, yes.
No other facts are required.
Yes,
Now we'll note some principles of law here.
absolutely.
Section 11
Yes.
Within
now
bracket
Lordship-
1
Yes.
of the
Section-
old act
Yes. 1894.
requires, mandates the collector to make an award under his hand in respect of true area of the land, comma, the compensation which in his opinion should be allowed for the land, and the apportionment of the said compensation, all the persons interested in the land. Whether or not those persons have appeared before him. Full stop. First proviso to section 11 within bracket 1. Section 11 within bracket 1 of the old act provides that no award shall be made by the collector of such officer or such officer as the appropriate government may authorize in that behalf. Second proviso to section 11, second proviso to section 11 within bracket 1 mandates that it shall be competent for the appropriate government to direct that collector may make such award without such approval in such class or cases as the appropriate government may specify in that behalf. In this behalf. As recorded herein above. 27th, what was the date? 27. It is seen that the collector forwarded his award to the government on 27/12/2013.
My lord,
Yes, sir.
27.
Thus, the award is to be dated on or prior to 27/12/2013.
My lord, my lord.
Full stop. Approval was granted. Approval was granted by the government on
Right.
29/1/2014. Full stop.
Absolutely, my lord.
As an approval was sought as an approval was sought, this court can safely presume that the appropriate government directed the collected not to make such award without approval of the state government in terms of proviso 2 to section 11 within bracket 1. Okay?
Communication to
Within bracket 1. So what will be the effect of this? Mister?
My lord,
I have recorded these two provisions of law. Now, what will be the effect of approval? Whether until and unless an approval is granted, can it be said to be an award? Because section 11 subsection 1 clearly says
Yes.
you cannot, it will not be an award.
it
We'll
will not
see.
be- Yes, now, my lord, lordship will see if lordship is taking up that affidavit.
Mm.
My lord, I'm troubling my lord with that affidavit. My lord, that additional affidavit.
Mm.
Lordship may kindly come to page 19.
Tell us.
Yes, now here, my lord, you see, my lord, here it is a communication from the revenue department to the deputy commissioner, with all respect. Here it is stated, with reference to the above, I am directed to forward here with an approved copy of the award. Now, the award is already approved. It has been communicated on 29/1/2014.
When the award was approved,
Now, to that extent, my lord, the materials are silent.
Then-
So therefore, my lord, in the subsequent affidavit, with all fairness, we have stated that we have approved it on 29 January 2014. Let us take it as 29/1. We have taken that stand.
Okay.
Now, my lord, here we have to now go by the legal fiction.
legal fix.
Legal fiction is that, my lord, provided further that it shall be competent for the so and so. Now, proviso lordship has said, my lord, provided that no award shall be made by the collector under this subsection without the previous approval of the appropriate government or of such officer as the appropriate government may authorize in this behalf. So award will attain finality once it is approved by the government. Now, government approves the award, we take it on record, my lord, that it is on 29th January 2014. 2013 Act came into force from 1/1/2014.
Hmm.
So there is a delay of 29 days.
Yes.
Now, if we come. to-
Thus, no. In the meantime, just I'm recording, this will be
My
fine.
lord, my lord,
Just,
my lord, we are obliged, my lord, lordship has cornered it down, my lord.
no, it's a match ultimately, isn't it?
Yes.
Then, okay, full stop. In the meantime, the new act was enacted. And the same came into effect from
my lord, on and from 1/1/2014.
1/1/2014.
My lord,
Full stop. Thus, in the case in hand, on the date of coming into effect of the new act,
yes,
there was no award.
there was
Yes.
no award.
There was no award.
There was no award.
There
Yes,
is no
yes,
award.
yes, yes.
Therefore, this court is to determine what will be the legal implication of such fact.
Right.
Okay, what is your case now?
Now, my lord will kindly see, my lord, section 24 of that 2013 Act.
Section 24 within bracket 1 within bracket A of the new act deals with
20, it is.
a deeming provision prescribing prescribing the circumstances under which land acquisition process under the old act shall be deemed to have lapsed. Full stop.
My lord. Now, my lord,
Deemed to
20,
have lapsed. A view was taken in the case of Indore Development Authority versus so. However,
Manohar Lal and others.
Monolal and others. However, on a reference to a larger bench, the Constitution bench of the Honorable Apex Court in
My lord,
Indore Development Authority reported in so laid down the following propositions of law.
paragraph 366.
Who will write all this?
My lord.
Ah.
If your lordship permits me, my lord, may I just read the relevant provision portion, my lord?
No, we'll come to that. Just
Yes,
listen to me.
Yes, yes.
Laid down the following proposition. Following proposition, just correct me.
My lord.
No. It was dealt by a determination was made. The issues before the Honorable Apex Court was to the following effect. 1, Roman 1, whether the word within inverted comma or in section 24(2) of the Act 2013 used between possession has not been taken or compensation has not been paid to be read as within inverted comma and Prashnaboda. Then whether proviso to section 24 within bracket 2 of the old act has to be construed as part thereof or proviso to section 24 within bracket 1 within bracket B question mark. 3. What meaning is to be given to the word within inverted comma paid under section 24 within bracket 2 and inverted comma deposited used in proviso to section 24 within bracket 2. 4. What are the consequences of payment not made? 5th, what are the consequences of amount not deposited? 6th, what is the effect of person refusing to accept the compensation? Correct?
My lord.
The Constitution bench, after elaborately dealing with the provision of Act and certain principles of law, concluded the following. 1. Under provisions of section 24(1) within bracket A, comma, in case the award is not made as on 1/1/2014, the date of commencement of the Act 2013, there is no lapse of proceeding. Compensation, however, compensation has to be determined under the provisions of Act 2013. Now, what will happen in this case?
Therefore, my lord,
Okay. In the case, the award has been passed within a window of period of 5 years. Isn't it?
yes,
Excluding the period covered by an interim order of this court. or order of court, comma, then proceedings shall continue as provided under section 24(1) within bracket B of the Act 2013 under the Act of 1994 as if it has not been repealed.
Now, 366(3), my lord, I will be heavily relying upon my,
Next paragraph.
yes, 366.
The word or used in section 24 within bracket 2
My lord,
between possession and compensation has to be read as nor or as and. Both are nor and are within inverted comma. Understood? The deemed lapse of land acquisition proceeding under section 24(2) of the Act 2019 takes place, comma, where due to inaction of authorities for 5 years or more prior to commencement of the said act, the possession of the land has not been taken, nor compensation has been paid.
now deemed lapse. So here possession has already been taken. So there is no deemed lapse.
In other words, in case possession has been taken,
Yes.
compensation has not been paid,
Yes,
then there is no lapse.
yes, I'm going by it.
Okay.
In my case,
Similarly, if compensation has been paid, possession has not been taken, then there is no lapse.
Yes.
Next, the expression paid within inverted comma paid. In the main part of section 24 within bracket 2 of the Act 2013 does not include a deposit of compensation in court. Okay. The consequence of non-deposit is provided in proviso to section 24. Rest are not important for these cases.
Because I will be relying only on 363 with all aspects.
Okay, rest we'll see, not
Right.
necessary. Full stop. Therefore, in the aforesaid context and principle of law, this principle of law, the learned Mr. Sharma, learned counsel for the petitioner, argues the following. Now you argue.
What's it?
1.1.
Point number 1, regarding approval of the award.
Hmm.
When the award is approved, then only it is comes into force.
Mr. Sharma, learned counsel contends that in terms of subsection 1 of section 11 of the old Act, until and unless an approval is granted by the state government, it cannot be an award in the eye of law. And admittedly, in the case in hand, the award was approved on
29/1/2000,
29/1,
2014.
2014,
Yes.
and therefore, on the date of coming into effect of the Act 2013, that is on 1/1/2014, there was no award, and therefore, even in terms of the determination made by the Honorable Apex Court in Indoor Development Authority within bracket supra, the petitioners are entitled for compensation to be determined in terms of the new Act.
Secondly,
Second.
Lordship, the award which was paid,
Hmm.
that was under protest, it was received on 24/3/2014.
Hmm.
Page number 40.
Mr. Sharma further contends that though award was compensation was accepted, however, though the compensation was accepted on Mr. Sharma
24/3/2014.
24/3/2014
14.
2014, it was under protest, and therefore the determination made in paragraph 366.20 in the Indoor Development Authority cannot be made applicable in this case, inasmuch as when no award is there, the subsequent determination made by the Honorable Apex Court in Indore development within bracket supra shall cannot be made applicable. Yes, third.
Lordship, the handing of page number 42, the handing over and taking over of the. position-
Similarly, he contends that the handing over and taking over of position was also on
4 June 2014.
4 June 2014. And therefore, such handing over position shall also have no relevance so far relating to the applicability of the new act, inasmuch as when there was no award, the non-handing over of the handing over of the possession shall have no relevance. Rather, it will be an illegality committed by the state respondents. Yes, next.
And also the notice
Hmm.
under section 12
Hmm.
that was issued on 7/3/2014.
Note, Mr. Sharma further contends that the notice under section 12
12/2 of
within
the old
bracket
act.
2. Just a minute. 12(2).
Yes, page number 38. Lordship.
Notice under section 12(2) of 12(2) of
Of the old act, 1894.
what it says.
Section
Read it.
12/2 notice.
12 to, yes.
Notice under section 12 within bracket 2 of the old act was issued on
7/3/2014.
7/3/2014, that is after coming into effect of the act, inasmuch as section 12 within bracket 2 of the act prescribes that
Section 12 to the prescribes
Hmm.
that
give up,
the
give the book.
collector shall give immediate notice of his award to such of the person interested as are not present personally or by their representative when the award is made.
And therefore, that also indicates that such a notice could not have been issued under the 2013 Act. That's all.
That
Yes.
is the main contention, that's it.
Par contra. Mr. Borpujari.
Lordship, one thing also may come up,
Yes.
Lordship, because Lordship, in this case, earlier we approached before this honorable court also, in page number 43, in the read petition.
Hmm.
In that, Lordship, that is an extra 10 of the my read petition, Lordship. Then, in page number 44, on this honorable court has directed the responsible authorities that matter related to acquisition according to petition land acquisition compensation is required to be calculated on the basis of the new act and not under the act of 1894. However, Mr. B.S. Dekal and State Council submits that the new act is not applicable of the exemption under section 105 of the 2018 Act without expressing any opinion on the merit of the
That is,
case.
he no expression his opinion. Why should we record this?
Yes, sir.
Therefore, expression of opinion is important. This could have been done on that day.
Yes, yes. That is also the whole.
Yes,
So
that's all.
that's
Mm.
that's.
Par
it, that's it.
contra. Mr. Borpujari, learned counsel representing the collector. Collector,
Yes. sir.
revenue authority, you are the collector. Collector argues the following.
Number one will be, my
One.
lord, that both section 4 and section 6 notifications were published, my lord, in the Gazette, my lord, prior to 1/1/2014.
As both the notices under section 4 and 6 of the old act was issued prior to coming into effect of the new act, therefore, the land acquisition proceeding should continue in terms of the determination made by the Honorable Apex Court, comma, in Indore Development Authority, supra, comma, in the given facts of the present case.
Yes. No, second point will be, my lord, here, my lord,
Inasmuch as compensations were paid under the earlier act, position was handed over under
taken-
the earlier
possession
act.
was taken.
Position was taken over.
Prior to coming into effect of
Possession was-
1/1/2014.
Position was taken over prior to coming into the coming into effect of the new act.
Anyway.
That's all.
Yes. Prior to coming into effect of the new, because my lord has, my learned colleague has drawn my lord's attention to those pages. Those are handing over. But we have to take the possession. Collector. takes the
Where from do you have taken over? Any record that you have taken over the position?
That is the pleaded case. That is the
No, how the position is taken over under the act?
possession is taken over, my lord, because that will be.
Because it will vest on some date
Yes, yes, that.
under section 6.
Yes, section 6.
Inasmuch as
Section
it
6.
is his contention that by virtue of the mandate of section 6 of the old act,
Yes.
after issuance of the notice, the acquired property shall vest upon the state, and accordingly the state has taken over the land, taken over possession of the land in question
On 23rd of December 2013 itself.
on 23rd of December 2013. He refers to which the pleading.
Yes, my lord, the annexer C to the additional affidavit.
In support of his contention, he refers to the annexer,
Annexer C, my lord.
annexer C,
That is, my lord, section 6 notification.
annexer 6 to the additional affidavit. That is a notification under section 6.
C, my lord, annexer C.
Annexer C.
Annexer C, my lord, to the additional affidavit filed by my lord, respondent number 3.
3. That is what I'm saying.
Yes,
Additional
yes.
affidavit respondent number.
It's a part of the record, my lord. Because if possession is not taken, my lord, one cannot issue section 6 notification.
So you are basically relying on paragraph 4, subpara 4, 366.
Appellate
Or-
3.
3.
Three.
The word or
Or-
used in
yes,
section.
Yes, yes.
Okay.
There, my lord, in the latter part of my lord, that particular paragraph, I am
In
reading it, my
this
lord.
regard, Mr. Borpuzari also places heavy reliance on the determination of the Honorable Apex Court made in paragraph 366.3.
Point 3, my lord, I'm so obliged, my lord. Here it is specifically, it is said, my lord, in other words, in case possession has been taken, it doesn't speak about handing over. Compensation has not been paid, there is no lapse.
Mr. Talukdar, appearing on behalf of NHIDCL, argues the following. Argues that the land was initially acquired by the state for their department, that is Public Work Department within bracket National Highway. And therefore, the NHIDCL was nowhere involved during the land acquisition process. Full stop. Subsequently, the project of construction of the road was handed over to NHIDCL with free land, and therefore they should not be fastened with the liability, even if this court decides that compensation is liable to be paid under the new act, for the reason that they continued with the project and completed the road on the basis of free land. Full stop. That's all.
Only one thing I want to,
Lordship, I am sure relying that into development para 3663, Lordship. I am-
Okay, Mr. Talukdar, while endorsing the argument of Mr. Borpuzari, also places reliance on the paragraph 366.3 of the judgment of the Honorable Apex Court in Indore Development. Full stop. While countering the argument of Mr. Borpuzari as regards paragraph 366.3, Mr. Sharma argues that, yes,
Lordship, section
you have
24.
time till 27th,
Yes,
everybody, yes, then.
Lordship.
Hmm.
And one thing, Lordship, just I want to place one page number 48 of my read petition. One thing that has the, because earlier order, kindly come to that part also. That is very important.
48.
48, annexure 12, Lordship.
48 annexure 12.
Yes, annexure 12, Lordship.
48. Okay.
That was- With the manipulation, the notification letter on the declaration, where is letter on that part? Where is the public notice?
Were issued.
Yeah, public notice were issued on 13/1/2014, fixing the date for filing claims and objection, if any, from the person interested on 28/1/2014.
Referring to the order dated 27th of October 2015, passed by the Deputy Commissioner in terms of this court's earlier direction, Mr. Sharma submits that admittedly, the notices, public notices were issued on 13/1/2014, fixing the date for filing and claims and objection, if any, from the person interested on 28/1/2024,
2014.
under section within bracket 9, within bracket 1, within bracket 2, and within bracket 3 and 4 of the old act. Therefore, the argument of Mr. Borpujari that land was taken over prior to possession of the land was taken over prior to the coming into effect of the act has no legs to stand.
That's it.
That's all?
Yes, Lord, sir. And that is also one thing. Similarly, the award was also made on so and so without giving any opportunity being heard. That is also reflected the condition. 27/12/2013.
If further highlights that admittedly, the awards were passed by the Deputy Commissioner without even issuing any notice on as on date. That's all?
Yes, Lord, sir.
Okay, on the prayer of the learned council for the prayer of Mr. Sharma, so and so learned council, list this matter on 27th. Your part is on 27th.
Yes, not-
27th is?
Tuesday.
Tuesday?
Tuesday, my lord. Yes, my-
20, yes, 27.
Heard in part, leave this matter for further hearing and usually give this matter. 2015 will at least be ended.
Yes.
My lord, my lord.
Huh?
So we are obliged, my lord.
80% is done.
Yes,
Yeah,
yes, yes. Yeah,
We are
agree to that.
long
Yes.
drawn, my lord.
No, instead of hearing you, then we have shortened
Ultimately, It will
the
really boil down, my lord, whether it is this way or that way, my lord.
paragraph 1 or paragraph 3.
Paragraph 2
Oh,
or my lord,
yes.
1/1/2014 is the cutoff.
Cutoff
date.
date.
That is the magic
Yeah.
number, my lord. Lordship will determine, my lord.
Earlier, Lordship, 2007, Arup Goswami judgment.
If you
also-
can rely on some other judgments also if you want.
Yes, Lordship. No, Lordship, what happened, the better is 2015. In 2017, Justice Arup Goswami was passing one judgment, relying that the amount is paid as per the award, approved award, so paid award. What happened thereafter, for filing the calling records, everything, so it took long time. In 2022, while that was, then they said that the National Highway is the required party. So many years, then they said PWD. Let's say your own authority, you had not submitted before earlier, now you are coming, taking this or that part. So that's why the matter. was
Talukdar is
taken.
clear, he has his instruction.
So,
He says no way out will pay. Isn't it?
no, Lordship
Then
has come to
one-
very correct
then-
point, because they will take now the everything, liability and assets as per the company like. So,
One issue may fall down, my lord, at the end of the day, if my lord is determining, my lord, as to under what provision of law, my lord, the compensation, if at all is to be revisited, then my lord, the second question that will fall out, remember, who is going to pay? Because then, my lord, the collector under the act is only the.
Therefore, we have recorded his
Yes,
argument. We'll have to answer.
facilitating agency.
Uh,
Correct?
We'll record your argument that
Yes.
even if assume you will counter
Well,
you will record your argument. Okay, next case.
So obligement.
Some instruction, but is not complete to file an affidavit. So
The authority
Accordingly.
itself has stated, my lord, that these are not complete instructions.
accordingly, he pays for 2 weeks' time to complete his instruction and file affidavit. Prayer is allowed, list after 2 weeks.
And so obligement.
Please, your lordship.
Yes,
Lordship, the matter pertains to, my lord, the death of an UTP in a mysterious
but now
circumstance.
tell us, when everybody says it's due to cardiac arrest, Now, even the committee we have constituted, now what to be done?
My lord, here, my lord. This court, my lord, on several orders, my lord.
No, no, we have directed for a report also. From the
Has come, my
Huh?
lord. This
Report has come. Report also says that I have taken, everybody said he was normal, he was reading a book. We have taken witnesses, everything is there. Now tell us what to be, under judicial review, we understand. If it is a, say, custodial debt or an unnecessary debt under custody, of course we can. And onus lies upon state to say that this is a necessary debt. But in the given facts of the present case, even we are ignoring the one-man committee. The court appointed committee, after taking so many evidence, has also come to a conclusion that there is no negligence on their part. Now, in that view, what should be done? Come to the point.
My lord, this court, my lord, on on earlier orders, my lord, there is in the, my lord, the post-mortem report. Post-mortem report. There was a
Forensic.
to rule out the cause of death due to poisoning. Sarah was sent for forensic examination. But my lord, that was not placed before this court.
Yes,
And
who will place
thereafter,
them?
my lord, this court, my lord, directed to go for, my lord, for judicial inquiry.
Inquiry.
But my lord, whether death was what in regard to death, my lord.
You go
What is
through
there
it.
in
You
the-
go through it and think, have you gone through it?
My lord, I have not gone through, my
You
lord.
go through it.
My lord, can you?
I'll
can
give you a copy.
Yes, yes.
I'll give you a copy. This court, under its order dated 23/1/2024.
Yes.
Two aspects are there. You just go through it.
23-1.
Basically, it may not be a date of custodial torture, but when there is a date and it is an unnecessary date, then of course, its state will have to explain. No doubt about that. We are not saying that somebody has killed him. But when a person is the custody of a state, maybe in jail or judicial custody, it is the onus of the state to protect him, give proper treatment and all. So, and a 30 years boy dying a cardiac arrest is not necessary in a normal parlance. But after inquiry, everybody said that there can be a heart disease like this and this can happen. Now, in that view, what this court can proceed. So therefore, you go through the inquiry. You have not gone through, I think, inquiry report.
Yes, sir.
So go through the inquiry report. Full stop. Pursuant to this court's order dated
23-1-2023.
23/1/2024, the learned district and session judge Golaghat has completed his inquiry and forwarded a report which is marked as flag Y. Full stop. A copy of the report be furnished to the learned counsel for the petitioner by the registry so that he can respond to such inquiry report. Full stop. List this matter on.
A week, my lord.
May I have a copy also, my lord?
Okay, a copy of this inquiry report be furnished to the learned counsel for the petitioner as well as to MSM Bormon, learned state counsel.
But if the deposition is also available.
Hmm?
Whether, my lord, the deposition is also
No,
available.
it's
That
report
is-
only.
huh?
So once I go through, my lord, it's report only. Deposition and all these things are not.
That deposition he has recorded. We will not disbelieve this officer. He has recorded the division, how he is put question or do. This is not a trial as such.
Yes, ma'am.
That to that extent will not go. And there is no injury mark and all in them.
Yes, my lord.
Yes.
That is.
List
that
this
is
matter on
First week of September, maybe.
first week of September, give it 5th of September.
Deeply. observed.
Deeply over. Me, please. Sure.
So, my lord, my learned friend is my lord. In this case, my lord, Mr. B. Goswami, my lord, additionally, he will assist the court, my lord.
Today, due to waterlogging, he cannot come, my lord. Can it be taken up tomorrow or day after tomorrow, my lord? Any day?
Day after tomorrow, I'll be not there, my lord.
What is the prayer?
Here, my lord,
For my lord.
The main prime accused is absconding.
my lord, Prime Minister, no, my lord, there were acquittal, my lord.
No, acquittal granted to the bank officers only.
Yes, yes. Prime Minister is absconding.
Yes.
Prime accused is absconding.
My prayer is that,
As for my lord, inquiry by the.
Are you still insisting on this?
my lord, because my check, that is which I filed before the Consumer Forum for negligence of the bank. That particular check, when was called for by the Consumer Forum, they couldn't produce it, the original. As a result, I
But you admit that, yes, I have kept it blank. And the forensic report says, what forensic report says?
forensic not a signature has been forced.
Report says.
Yes, my lord. And that is why the check was called for, my lord. To
No,
establish.
if forensic report says that then
But original check without original check, my lord, it is not possible to prove it.
now suppose everybody says that we do know it is misplaced. There was a direction from to the magistrate also.
Yes, yes.
What is that? What happened to that?
That medicinal report says that the
High
police
Court.
said that it was missed from the police station.
Report is on record.
Yes, yes, it's on record, my lord. It says that it was missing from the police station, my lord, itself.
Honorable Court in 4/4/27.
Where is the case diary?
My lord, original case record was called for. As
No,
per-
case record, there is no case diary. Okay, let Mr. MP go, because uh, along with the search sheet, you must have said that these are the documents you are relying on. There must be a form, where is that you have relied on the check? Then we'll ask the police to compensate.
That is my point, my lord. That is my strict liability will come upon the state, my lord.
So, it is submitted that Mr. MP Goswami, learned,
B. Goswami. B. Goswami, my lord. Biswajit Goswami.
B. Goswami, okay. Mr. B. Goswami, learned additional advocate general, could not attend the court due to waterlogging. Accordingly, a prayer for adjournment is made. Also, prayer is allowed. List this matter.
On 26th, my lord. Holiday. Then let it be on the, my lord, 1st of
1st of
October.
September.
1st
Sunday.
October. Oh, sorry. Sunday. 3rd September. my lord.
3rd of September.
3rd of September. Okay. 3rd of September. You keep this.
Can it be on the top of the list, my lord? Because 15 matters.
All matters are all top of the list.
I see it's 15 matters, that's why.
See, we are at 12:30, we are hearing you.
Okay, oblige,
On that day also, we'll hear you around 12:30. No problem.
oblige.
I pray for little accommodation till Thursday, my lord.
Where is Mr. Kyle?
No, here, the B. Gogoi or B. Chaudhary will appear in this matter, my lord.
Okay.
Kyal is for item number 8.
on the, you want to deposit them to go to the appeal?
We have already deposited to 25%, but during that filing of the appeal, we couldn't, for
You
financial cases, we couldn't-
subsequently,
yes,
you have
subsequently we
deposited.
have deposited, my lord, and now, my lord, our prayer is for considering the appeal on merit over there.
So for that, why you need adjournment?
My lord, the main things will be elaborated by N. Haveli only. She's on.
What is to be argued in this case? Or you want the name?
Yes, ma'am.
Name.
That.
On the prayer of the learned counsel for the petitioner,
Thursday.
please this matter after 2 weeks,
2 weeks.
on a date to be fixed by registry.
Before proceeding, my learned friend, as per last order dated 37/2024, my lord, I have filed affidavit. But that is not in record. I can give this or lordship.
What
may-
is your stand?
Stand is this,
Where
one.
is the Karbi Anglong?
Our stand
Okay.
is that day, by way of affidavit, I have brought it. His land has got damaged, which is land beyond the right of the way.
Mm.
Thereby, we have this one contact agreement along with the contractor, that it is to be paid by any damages caused to the contractor, which was damage was ascertained by So there's no dispute there.
You pay,
We also,
you
no,
pay and
here,
recover.
no, hear me, Lord, that is why if it a single man, single person, it would have been, my affidavit, why I brought it, that they also have submitted one. This is the dough that they have shown your lordship
Okay. Thursday,
Thursday.
Thursday.
Yes,
Mr. Borua, C. Borua.
Ailenegi.
Is saying that too many matters are fixed. on
No,
Thursday.
as it is, all after also it can be 28, 29, or 29.
29th?
Yes. 29, keep up.
First week of September, we'll fix a date. 2nd of September,
Second, my lord.
2nd of, come on, Mr. C. Borua, learned counsel for NHI, DCL,
Second means this will.
2nd of September.
Yes, yes.
You are for NHI, DCL.
NSAI,
NHI,
National Highway Authority of India.
NHAI.
Yeah.
NHAI submits that an affidavit has been filed by the said authority. However, same is not on record.
Record.
Accordingly, registry to verify and take the same if already filed and list this matter on 2nd of September
My lord.
for hearing. Mr. Borua, just think over it.
Yeah, no, just only off record I'm saying, what happened, my lord? Not only he, lot many. That is why it was matter has gone up to central minister.
There is a committee.
That there we have committed, and their names are already, I have suggested that committee, though I have earlier occasion, I have requested him, you go and proceed, but they have not, as matter is pending before your lordship, this burdens is getting shifted to me. That is, I have already instructed that this name should be placed the committee, already it's been sent to committee. It will be sent to committee, and my one paragraph also is there, that he may, because his grievances, we cannot keep on, is at least he can verify, he go to committee, because there, not only his colleagues also there. That is a 98
Okay,
point,
well, that's why we fixed on.
98.83 crores are involved. And honorable
What
central
kind
minister,
of damage is this?
The damage to the, my lord, property.
Paddy field.
Yes.
what happened, my lord,
Very
generally this is the road. Road we are paying, acquisition of land is doing that to us. Suppose contractor who are doing, generally they are doing so, that is why we have clause. Because what happened, we are cutting,
No,
art cutting.
That we understand, cause is there.
And the cause is there. Cause is there. Now question will be before lordship, who will pay this? We are saying the contractors to pay. Even my lord, off record I am saying, if contractor would have been working this place now, I would have requested them to, not requested, even asked them to deduct from there, but this contractor also not with us now. That is, they have from.
But you have a responsibility.
Yeah, that is why that-
Upon your agent,
that
that
is-
sees
that
that
is why-
list,
that
because
is why,
ultimately
my lord,
property belongs to you.
Considering so only.
Suppose Mr. Borua constructs a 7 stories building
Yes.
and his construction by his labor
yes.
contractor damages the
That
plot of
is-
Mr. Borua next to him.
My lord, one thing, I
Who
am,
will pay?
I am
The next
very
bill
well
will
with
not
him.
pay.
He will be paid. Now, that is why central government has asked to our chief minister by due letter that they are lordship
Yes.
in. Then this 98.3 crores will be paid to all affected person, not only him.
Okay,
Will you going to pay?
My lord, my sir, that access is already over, my lord. Payment
What
already
restriction my still latest.
Okay,
committee-
we'll on to
committee
this.
is there.
That is
Mr.
over.
Borua,
He doesn't want to go. That is the problem to before committee.
we'll see, we'll see, we'll see.
He wants your lordship order.
We'll see on transition. Yes,
2023. Okay.
yes, next case.
Right, reasonable.
Yes,
But I'm informed that state has filed some.
this is item 7.
Yes,
Yes,
some charge sheet has been filed indicating the name of the petitioner as a witness. The police firing incident. Well, the case is very strange. Well, an incident of police firing took place on a mob. From the very beginning, I've been
in the
saying I am
charge sheet, you are witness.
I'm a My lord. witness.
So therefore you are not involved.
I'm not.
You are
involved.
not an
That is
accused.
the exact case that
So
I've
pay
been-
compensation,
My
Mr.
lord,
and
in
sir.
this matter, we are only seeking one day accommodation. My lord, K. Gogoi is in court number 2, my lord.
So that was that was in my mind, that suppose an accused who is ransacking the public project, can we protect him? This was the
Yes.
was working. Then if he is a witness
Yes,
and not an accused, He is a victim of that
I
incident. You
agree.
could not protect him. Pay him the compensation. What?
That will be a limited relief, my lord, nothing.
It will not be, it will not take more than 10 minutes to us. When?
Next week, any day.
Next week, we have already fixed methods. Many methods are there.
Let it be on
Tomorrow,
third.
tomorrow,
My lord, I may be excused.
third. On the prayer of Mr. K. Gogoi, matter stands adjourned and be listed on 3rd of September. Third is a Wednesday, Thursday, what?
Tuesday, my lord. That is why.
I prefer respondent number 8.
Okay. You are responding, who is responding?
Where the petitioner was,
He is actually the Union of India, the military hospital where I was first taken after
Okay.
the bulletin.
Okay.
My lord,
Yes,
the
Kyle,
same-
what is this?
Same prayer for Thursday, my lord. Thursday or tomorrow. Thursday.
Lordship,
No,
normally I don't oppose any adjournment, but in this case, Lordship, I have objection.
Why?
Lordship, the conduct of the petitioner, Lordship, may please to see. Every time they are seeking adjournment. Lordship.
What is the issue here?
Issue Lordship, they are seeking benefit of one
Applying
notification.
for
That,
central excise,
that tax
Central-
exemption,
Yes,
excise
excise.
exemption.
under central excise, my lord.
And then notification Lordship, admittedly, they are not entitled.
Not entitled.
Yes, Lordship. Lordship, normally I don't oppose, my senior taught me that don't oppose any adjournment of the, but in this case, Lordship,
Yes.
Last time, my lord, we have not taken time. It was in the order. It was in the order. That's why it was fixed for hearing. And only one day accommodation, my lord, on Thursday, my lord.
Thursday, we have fixed so many methods. Wednesday,
Tomorrow,
tomorrow.
oblige me.
On the prayer of the learned council for the parties, list this method tomorrow. 30 days.
Item 10.
Yes, Barbara.
This is the case against Food Corporation of India. Affidavits have been exchanged.
Hmm.
My lord, in a nutshell, my lord, the facts are like that recovery of certain amounts, my lord, without giving any notice unilaterally issued. I was not given any opportunity to confront. My lord, FCI floats a tender in 2015 for, my lord, various handling transportation work. And I bidded for this, being the most competitive. I was appointed by page 24 appointment order, lordship,
Yes.
page 24.
Yes.
Well done. This was an order of 21 January 2016, appointment of handling contract at Balajan. It is in the Kokrajhar district on regular basis for a period of 2 years. So I was appointed. I deposited, my lord, the requisite security deposit, earnest money, bank guarantee, etc. And I commenced work without any blemish. That was a contract 2016. I concluded the contract, my lord.
It was a period for
2 years. It was written in the order, page 23.
from 13/1/2016 to
For 21/1/2016 to 21/2018.
where do you get that?
My lord, page 24 order is clear.
No, just line.
Page 24, my lord, is subject. Appointment of handling contract.
Handling
for-
contract, which is for a period of 2 years. That's why it started from
It was started from the same day, my lord.
same day, 21/2016. Okay.
I commenced work.
Okay, then
Then, my lord, I concluded the contract
Hmm.
without blemish successfully on 21/1/2018. Today we are in 2020. All my bills were scrutinized and paid by respondent authority. Thereafter, FCI even released my security deposit and bank guarantee, etc. These are released only when the FCI gives a no demand certificate under the hand and seal of the concerned authority, which your lordship will find at page
26.
26. Only after conclusion of a contract, if either of the parties to the contract had any claim against each other,
then
doesn't have any claim, therefore forwarding of the no demand certificate. And this is written by the area manager to the general manager I am forwarding here with no demand certificate certified by concerned depot in charge, orders and countersigned undersigned. So nothing remained, my lord. It was a foregone and concluded contract. Thereafter, the contract came to its conclusion in January 2018.
What is page 27?
I am coming to that, my lord. Lordship. Thereafter, I got another contract. Lordship will see at page 29.
Yes,
Page 29.
yes.
It is in a, I work under at various places under FCI.
Hmm.
This is of 2019 contract. It was ad hoc contract initially for 3 months, then extended. Page 29.
Hmm.
I am drawing your letter. This was a contract to be, my lord, handling contract at Hoiborgaon railhead. So I completed this also satisfactorily. But however, in the work, in this particular work, only rupees 8.8 lakhs paid to me, and I have not been paid around 14 plus 14 lakhs of rupees plus my earnest money and other deposits. When for more than 2 years, the balance amount was not paid, in spite of my repeated visits to the office, district office and regional office, nobody told me about for what reason the amount has not been paid to me. It is also concluded. There was no default on my part. Very recently, my lord, then I discovered and got hold of an internal communication between FCI authorities, which your lordship will find at page 34. They were not supplying it to me. That was an internal communication. Kindly have a note. It was of 26/10/2022 internal office note. It is given by the general manager. Recovery of amount from the then handling contractor against Balajan, the earlier contract at Kukrajar. Competent authority has granted the necessary approval for recovery of below mentioned amount of the then handling contractor engaged at Balajan under DO District Office Kukrajar, being the payment towards de-staking of same, so and so. I am, my lord, Konaka Tea Estate, 10 lakhs and odd. Then the relevant correspondence has received DO Kukrajar in this regard, along the commencement report, relevant papers of vigilance section file notes it enclosed. I am not handed over this. Necessary action may be taken immediately for recovery of the amount after following due formalities. So, kindly see, even it was not to me, it was their internal note. No copy was forwarded to me. It was issued unilaterally by them without giving me any opportunity to confront as to why, where from, why 10 lakhs you are recovering. Then, my lord, by
Now, where
next
is the
page,
order of recovery intimated to you?
yes, now, my lord. Never. Then page 35. Next page. 3/11/22. Now this is from the Assistant General Manager contract to the Division Manager Nagaon, where I concluded my Hoiborgaon work. Recovery of 10 so and so amount. RO Vigilance so and so. Copy established. This office letter so and so. Copy enclosed. Kindly see, no copy has been earmarked to me. It is also a sort of unilateral office note where a decision was taken against me. And I completed. Then kindly read. With reference to subject and letter cited above, I don't know what these letters are. These letters have never been forwarded to me. An amount of so and so lakhs and for so and so from Konaka Tea Estate, who was engaged in handling during the material period of loss of the aforementioned amount, is required to be recovered. Everything behind my back. In this regard, you are requested to make the recovery of 10 lakhs from the pending contact bills of ad hoc handling contract at Hoiborgaon. It relates to Kukrajar. Kukrajar I concluded 6 years ago. After 6 years ago, they discovered something and they gives it. They recover it from his Hoiborgaon account. So this is after 2019, 4 years thereafter. Here also no copy, no prior notice has been given to me. Then, my lord, all behind my back, not even a copy, no copy notice. I was never even called to the respondent's vigilance office. It appears that they made a reference to some vigilance letter.
Where is the set off clause in this contract?
Page 35. Lordship, I'll come. So, As I said, it was only after issuance of no demand certificate, my bills and dues more than 4 years ago, for any purported recovery, go to a civil court. How can you recover by withholding bills in respect of the entire defined contract? An absolutely arbitrary violation of my constitutional rights. And my lord, it is illegal, unconstitutional, and in violation of the, everything has been done behind my back. Now, this court on 17/2/23, it is in the note sheet. There was an interim intervention order passed. But by that interim intervention, Lordship will find it in a note sheet also, order sheet. 17/2. In this case, petitioner has appointed so-and-so for 2 years handling contract, FSD, Balijan in the district of Kukurajar. Claim of the petitioner is that not only the work has been completed in all respect, the bills have been cleared and even the security deposit was refunded. However, by impugn action which has been taken after 4 years from the date of completion
So
of
that is
the
22/2.
contract, a demand
Order
has been-
dated?
Huh?
Order dated?
Order dated 17/2, Lordship.
17/2. Thereafter 22 also. there
No, no,
is
17/2 order is 22.
Balancing equities.
Yeah.
No further.
Balancing the equities, however, it is directed that no further action be taken on the
There is
petition.
no demand notice. Where is the demand notice?
That was the demand notice, my lord, 3/11/22.
That page 35,
Yes.
36, 35.
Yes.
No, it is a communication between the
So
division.
that
and
the court has said demand notice, my lord.
No, this is not a demand.
Anyway. Page
Okay, Mr. Rashid, where is your
Then
power?
one thing, they have filed an affidavit. They have filed an affidavit. I have, it has been served. And I think it is not necessary for me to file any reply, and I am obviously not advised to file any reply. Because why? Because they have not denied anywhere in their affidavit that
No, they are not denying their action. Only their case is
It-
that we are empowered under clause 12 of the contract.
recover-
Let us see the clause 12.
and that they have got a dispute redressal forum
Hmm.
manned by FCI, alternative remedy. It's a case of out and out violation of natural justice, my lord. A series of decisions I will cite by this court.
Not
What
necessary.
is then be?
Not necessary. No decision is.
They have
taken.
not said whether any opportunity was given me to confront.
Yes, Mr. Rashid, tell us the clause. That's all.
Lordship, may peruse affidavit in opposition, page 66. Page-
66 or 65?
It should be 66, my running page, my lord.
Running says 66. Clause,
Clause Roman 12.
Roman 12 is at page 65. Yes. 12, Roman 12.
Any sum of money
Hmm.
due and payable to the contractor, including security, deposit refundable to the contractor under the contract, under this contract may be appropriated by the corporation and set off against any claim of the corporation for payment of any sum of money arising out of this contract or any other contract made by the contractor with the corporation.
Okay, what is the procedure prescribed?
My lord, there is no such, the contract term doesn't provide. No, my lord, to cut short the whole thing, my lord.
That short means we are cutting it short.
Lordship, I will
No.
also, I admit one thing, my lord.
Let us not
that-
spend time on
No,
this.
no, That's why the.
See,
I'm-
even
I'm-
if clause 12 is
fair
there,
enough.
clause 12 is there,
Hmm.
if he has signed a contract, he is entitled for a
No,
notice.
I'm not on that.
That's
lord.
all.
I am not on that. I must be fair because what is the facts, my lord, stands admitted, is that there was no notice. There was no notice and there was no adjudication. The Lord Levy said, what is the manner prescribed? There is no adjudication of the amount payable dues by him.
Who will
Exactly-
decide that this
No, my
is the
lord,
set off?
Exactly on a similar case, exactly on a similar case, this honorable court was pleased to set aside, the coordinate bench of this honorable court was pleased to set aside the recovery order and all. And when it was, and directed to make payment. And against that, an appeal was preferred before the division bench. The division bench says since it is a public money, there has to be an adjudication. And then recovery process may be undertaken. Then the matter went to the Supreme Court. Supreme Court said that the judgment passed by the honorable court did not find anything wrong in it. Only said this adjudication has to be done by the GRC. Supreme Court has held, my lord, but the
We are
grievance.
not on that. Whatsoever you give a notice to him, demanding, there is in fact no demand till now. Where is the demand?
No,
You have
but
already marked a set off.
I admit, my lord, I admit.
So therefore,
But
this will
so-
go, then you proceed as per the contract, as per adjudication, what not, we are not
If
concerned.
the lordship provide that.
We are not concerned with how you adjudicate. That's all.
The only thing, my lord, since there is a, my lord, Supreme Court has directed.
Give us the Supreme Court judgment.
I didn't produce this. A series of single bens, all uniform view, without notice, natural justice. You cannot recover it.
My lord, I paginated it, seven
refund-
page, seven
one-
is the single
one minute.
judge's order.
Refund it.
And the
one
division
court
bench
also
order
directed
is at
for
page
interest.
4, and the Supreme Court order, the very first page. my lord. I just rely on this, because the same situation, no notice, no adjudication, therefore said, my lord, you adjudicate and then.
So therefore, see, this judgment only relatable to, Supreme Court judgment is only relatable to the forum.
Right,
Okay.
right.
Now, how the forum's adjudication will be initiated?
That has to be by, because Supreme Court has, in this case,
So
said you
what-
go.
let us.
Since it is a
let us-
contractual
let-
dispute.
Let us understand, what is the procedure before the forum prescribed by you?
My lord,
You cannot be monarch.
my lord, the contract provision says
Hmm.
the decision of the general manager would be final. This is agreed between the parties.
No, we are not on that.
Agreed.
We are not on that.
My lord,
Your
in
decision
a
may be-
contract, it will be governed by the terms. If the contract
No,
does not provide any.
We are not disputing any of these facts. Please answer to this. We are accepting for the time being that there is a provision which empowers you to set off some amount even from the other contract or the liability due. Okay, this power has been given. So you have exercised this power. Therefore, we are not going to your decision. Now we want to know what is the procedure prescribed for taking this set off.
The parties have agreed
Agreed to what?
that there may not be any procedure prescribed. It is it will decide, parties have agreed, it is depend upon the terms of the contract. If the
Understand.
parties,
What? Let us read the terms once again.
lordship will see.
Can you say that it will be set off? What set off? Which
my lord-
amount?
My lord, if the.
Do you
we cannot-
propose to
my lord,
say? Do you propose to say that arising out of this contract that some due is, so you will decide that this is the due. You will decide that this is set off.
This is what.
So there is no scope for
This
him.
is what the term says. Term of the contract says. It says the
The
decision
law
of
is
the.
equally well settled that until and unless principles of natural justice is
That's I
excluded,
admit.
it is inherent in every state.
That is, that I admit, my lord. That
That's
I
all.
admit. That I admit. I am not disputing that.
So therefore,
I cannot, my lord. I cannot.
therefore that will go.
That
You
may
proceed,
go.
you give him a notice, he may raise many
No, no,
questions.
that may go.
He might have set off or counter claim.
Rightly said, my lord, rightly said, but that may go, but since it is a public money and the amount, how your lordship will see affidavit, that he has stacked it, destacked it,
No,
again
we are
stacked
not
it.
concerned.
So this is a public money, therefore your lordship will
Her public money.
secure the
All
public
contracts.
money or public interest only. That's
Where
my
is the division
submission.
bench judgment?
Contract is a public.
My lord,
Division bench judgment?
divisional judgment, my lord. will-
Yes.
Reference to due.
Judgment at page 4, I paginated, my lord, for your lordship convenience.
Yes, number given.
Repetition WPC number 3261. 3261 of 2016.
Copy 9.
Copy আছে না? 2009, copy 9. That was division. That is the Supreme Court.
That is Supreme Court, FCI. Yes. EB. এইটো কেতিয়া?
এইটো হেৰি ৰ'ব 7 নহয় ৰ'ব last ৰ'ব 14
এটা ফটো নানে কেলে?
See, Mr. Rasuduri, there will be many questions if we go deep into. Okay, suppose there is a term of set off. To what period setup will be there? If you say that if we are silent, it will be time immemorial. Can be a money claim. We'll have to interpret then.
No, my lord, this, I think, my lord, in view of the
No, that's
Pro-
fine.
provision of the Contract Act, my lord, one cannot say section 28B is there, my lord, number one.
Anyway,
I leave it to your lordship because lordship will, my prayer would be.
we'll
to
say
s-
that
to
this
lordship will
is
secure the-
absolutely violative of principles of natural justice. We'll
And-
set aside and a notice should be issued
No, that-
and how they
no.
want to
No,
propose.
no,
Then he will have liberty to take all the grounds that that is
that
available.
would be appropriate judgment of lordship. That is
In all these cases, normally kindly see, this is but by limitation if they go to the civil
So
court.
that too.
Lordship will not regularize that.
No, we'll not regularize.
No, no,
No, we'll
none of the
still-
judgments. None of the judgments, there are about half a dozen judgments, single by, all this type of withholding of money.
No, in this
Set
judgment,
aside.
same clause,
No,
same.
Lordship will not give them any rider. Simply, it is a violative of natural justice, it is gone, you refund the money. Then they should know. which
No,
for-
what is your prayer in this writ petition?
I am prepared, kindly have a look. This type of handle, my lord, will outrightly, my lord, arbitrary action. Prayer reject in none of the cases,
Page 17, my lord.
none of the cases. In that case, I will refer to the cases, my lord.
Page, what is your prayer?
17, my lord.
Page
Of the
17.
writ petition.
That way they will never release the amount. Any rider. Yes. As to why the internal office note dated so and letter L, K and L shall not be declared illegal, unconstitutional, mandamus directing respondent not to adhere to recover, already recovered. Immediately disburse the bill submitted in respect to at that time, completed at Hoiborgaon. In execution of this one, may be pleased to issue such judgment. So immediately they should 10 lakhs and odd, they have, my lord, recovered, they should refund it.
No, Mr. Barbara, yes, I understand. Now, what do you say about this Supreme Court judgment? Are you having a copy?
No,
I can.
not-
See, it says that adjudication should be in terms of the grievance disputal mechanism.
Except to this one.
Hasn't he?
My lord, in all these cases, the decision. Yeah. 504, there should be consistency. 504 division, kindly have a see. Natural justice violation,
There is no doubt about that.
kindly have a see. Simply court sets aside that it is illegal, we are not going any further. It is for you.
No, this is by our High Court, but the Supreme Court.
Yeah, it's all right. Supreme Court, the lordship will see. I have also got my lord Supreme
No,
Court.
this
decision.
judgment is from, Supreme Court judgment is from our High Court or something different?
Our High Court.
Our High Court, similar, that's why we are saying,
See?
otherwise we could have
It's our High
distinguished.
Court.
No, the Supreme Court dealt with a determination made by our High Court. Our High Court passed an order like that you have prayed, then it went to division bench. Division bench says single judge is correct, set aside, but they should be given a chance and they can do for arbitration and all. But Apex Court says that no, it should be the adjudication mechanism.
And without
No,
it
my
being
lord,
influenced,
they-
without being influenced by any of the observation made by the either of the single judge or jury. That is the line of the.
Do you want to go through it? Mr. Barbara, just address on this. That's all.
I'll-
Otherwise, we are satisfied.
I will address it.
You address on this,
Hello.
what will be the implication of these three judgments?
I'll furnish a copy.
We are taking up some other day, tomorrow or day after tomorrow or Monday.
That is on Monday.
I'll
Monday?
furnish a copy.
Tuesday.
Monday.
Tuesday, how many matters are there? This will take not much time.
They did you.
I told you.
I'll see.
Tuesday.
And I will also produce
huh.
one of the cases going from our High Court
Huh.
as well as Tripura High Court,
Huh.
where money was recovered, Supreme Court.
Okay, you bring it.
They are straightway.
Hmm?
Go wherever you want. We are not going to say.
Okay, that's why. So since he's relying on, give a copy, treat these three judgments.
I'll leave it right now.
Just
Supreme Court, madam,
Okay,
I guess, say,
huh.
3-4
list this matter for hearing once again on Tuesday. 27th,
Part
it will come. All matters will come to this bench.
Supreme Court has a lot of issues. I can show a order.
My lord, I have a small prayer regarding item number 5, my lord.
Yes.
Can we take it tomorrow, my lord? They have already reached, my lord.
Which file?
Item number 5, my lord, regarding make
What about
5 and 8, both the matters.
one is tomorrow, other one is Tuesday tomorrow.
Both the matters, my lord, 5 and 8 can be taken
Tomorrow.
tomorrow, my lord. We are ready. Highly obliged.
All right,
We'll take up this matter on
yes,
Tuesday.
my Tuesday,
See,
Tuesday.
we have no quarrel on that this action cannot be done. But a
Unsustain-
new proposition, new dimension he has argued, we want a response from him.
Unsustainable, whether the, only question will be whether the court in a situation like this should give.
We'll go
the-
further, yes.
I'll be addressing on that.
So your
I
argument
think-
will be already law is there, you do whatever you
And
like.
I'll
Why
bring-
should you
I'll
want
bring
a?
some other Supreme Court decisions in contextual matters?
Okay,
Be it
fine.
FCI or any,
Yes,
the
fine.
principles will apply.
Deep